Your Honor, may it please the court, Trent Wetta of Hinkle Law Firm, on behalf of Judy Sullivan, the administrator, CTA.
May it please the court and counsel, Douglas Cranber on behalf of Frank Bly and Esme Pearl.
Mr. Mills, you're muted.
Okay, Williams on behalf of Susan.
Mills, you're muted.
Joy K. Williams on behalf of Susan Davenport.
Can you hear me now?
I can, Russell.
Okay, all right. Russell Mills appearing on behalf of Mandy Holderman and Air.
All right. This matter comes before the court at this time regarding two attorney fee issues. One is a petition of allowance of interim attorney fees filed by Mr. Cranmer. I think what originally initiated the proceeding before the court today was the request for interim attorney fees filed by Mr. Wetta, I think on behalf of his firm, and objected to by Mr. Mills. I think what I'm inclined to do is start off with Mr. Cranmer's petition, and then we'll move to the Trent Wetta claim in this case. All right. I have a question for you, Mr. Cranmer. I saw in some of the attorney fee billing statements some discussion of family settlement agreement. Has there actually been one reached, or will there be?
No, we thought we had one reached, but ultimately we weren't able to get it done.
Okay.
For Pearl's 4 children, at least 2 of them rejected it, and we couldn't get anything worked out with them ultimately.
Okay. Always optimistic. I thought maybe that was going to take place, which might help resolve some or all of the issues we have before us now. Now, as I understand the current status of your client's claim, this is an issue up on appeal at this time, and I think you've already filed a brief. Is that correct, Mr. Cranmer?
That is correct, Your Honor. I filed my brief, and we're still waiting for the briefs of the appellees in this case, which, be coming down the road at some time, I'm sure.
All right, which begs the question, it would appear, just based on what this court's knowledge is of whatever issue or issues might be up on appeal, that everyone else should be united in interest, that there's not a separate interest from Mr. Wetta and who he represents, Mr. Mills or Ms. Williams. Would you agree with that, Mr. Mills?
Yes,
that's consistent with your objection. Ms. Williams, would you agree with that?
Yes, Your Honor. I think the 3 of us are united in interest at this point. Yes.
Then why can't you 3 get together and file one brief in combined fashion and cut down on perhaps 3 different lawyers essentially taking the same position on appeal?
I would agree to that, Judge.
Of course, you'd have to talk among yourselves as to who's going to do that. But it does seem unproductive to have 3 separate briefs filed by persons who essentially have the same position in the case. Mr. Cranmer's obviously is adverse to you 3. As I understand it, he's still pursuing a Strobel type of claim up on appeal.
Your Honor, could I address that just real quickly?
Please do, Mr. Mills.
Your Honor, as to Mr. Wetta's request for fees, I'm not challenging that. What I'm kind of hitting on is what you're talking about right now. I don't believe it's necessary for Mr. Wetta to be involved in the appeal, because we do have other attorneys who are able to go forward and present the response in the appeal of the appellees. I've prepared one. I'm almost ready to file it, Your Honor, and I probably will file it either later today or tomorrow. But it doesn't seem to me that it's necessary for the representative of the estate to get involved in that, because once the Court of Appeals makes its determination of Mr. Cranmer's ruling, I mean, this case is pretty much over. And then the estate's counsel can start closing out the case. So it's my position that the estate can just sit back and wait to see how the Court of Appeals rules, and then how you rule as to the fees after that, and we're pretty much done. So I think you're hitting right on something that I was looking at, Judge. Is I think we have an obligation to try, if we can, to keep the fees down as much as we can. And I think I've, tried to do that. I think, and again, I'm not attacking anybody's fees that they've presented here. These are honorable people, Your Honor, and I have no problem with their fees as they've presented them. But I do believe that we have an obligation to the overall estate and to the beneficiaries to not incur unnecessary expenses. And I think that's what 591717 says, that the representative of the estate can be paid for their necessary expenses. And I think this just isn't a necessary expense. So that's the only objection that I have to Mr. Wetta's fee request.
All right, Ms. Williams, would you like to weigh in on this issue?
Your Honor, I'm a little distressed that just between Mr. Mills and Mr. Cranmer, we're already looking at $100,000 in fees. At this rate, and we haven't even gotten to the appeal. At this rate, we're going to diminish this estate rather quickly, and I haven't filed for my attorney fees yet. I am really concerned about how quickly we seem to be running through our clients' money at this point.
All right. Well, I hope the attorneys in this case are not under the impression that each one of you will be able to submit a separate claim for attorney fees and be paid out of the estate. The court does not read the statutes or the case law in that fashion. This court very well may limit, if not just completely preclude, reimbursement of your attorney fees from the estate. And this would be at least part of the court's rationale. Let us presuppose that Mandolin Holderman and Susan Davenport receive substantial amounts from this estate. That's not 100% clear at this juncture with the case up on appeal, but they would have their own assets in which they could pay their own attorneys. A lot of the litigation in this case has taken place as a result of the failure of these parties to get together and reasonably discuss resolution of these issues. There's been a lot of unnecessary briefing and argument in this case that certainly may not be compensable by the estate itself. Now, I do understand, Mr. Mills, you have, in the view of this court, upon review of the file, at least somewhat of a claim for initiating the proceeding, which eventually led to a number of court rulings. In this case, you certainly have the argument that you are entitled to have the estate as a whole reimburse part or all of your fees in this case. But a lot of the litigation in this case has been in enlightened self-interest only, not to benefit the ultimate beneficiaries of the estate in the truest sense, but rather just litigate and bicker back and forth with one another. And it seems wholly unfair to the ultimate beneficiaries of this estate, whoever they may be, that the estate is being eaten up by litigation involving a number of different attorneys in this case. So if you're under the impression that this court construes Kansas law for the proposition that each one of you is going to get the full amount of your claims for attorney fees, no matter how inflated they may be, in other words, inflated past what you are reasonably and necessarily entitled to, or perhaps even whether you're going to get it from the estate as a whole, or this court will just simply take the position your clients can pay your bills. That's yet to be determined. The court considers that ultimately to be a matter closely connected with final settlement of the estate. I'm also troubled by the ongoing amounts that are being billed by the administrator CTA's attorneys. This court already made a considerable allowance of attorney fees in this case. Now there's another $18,000 claim before the court, and they haven't even dealt with the appeal yet. So I don't see this estate to be that complicated that the administrator CTA's attorneys are going to be billing an additional tens of thousands against the beneficiaries of this estate and expecting them to pay it. Mr. Weta, this court will make a ruling at this point that this court is going to disallow any further claims by your firm for direct reimbursement from the estate until final settlement of this case. The court needs to see the entirety of what you intend to bill. And with the size of the estate that may be left following this court's decisions regarding other attorneys in this case and the apportionment of the ultimate estate before it makes any final decisions as to what it's going to allow the administrator CTA. With that said, if Judy Sullivan herself, as the fiduciary, wishes to advance monies to your firm to pay you to pursue this defense of this appeal, then the court can take up the issue of reimbursing her from estate assets at time of final settlement. If she doesn't feel that it's worth the investment of her personal funds to hire you to pursue a defense of the appeal, then the court's not going to compensate you for doing so. What the court does need to establish, however, is that there is an agreement among counsel that someone's going to defend this. Because if no one else is going to defend it, my position might change. I have no doubt that Mr. Weta and his firm would do a spirited defense of the appeal to try to uphold the court's existing orders. They've been consistent on their position from the beginning, and they've done quality work. But Mr. Mills, after seeing your response to their request for fees at this point, I'm inclined to agree with you. There doesn't need to be separate briefs filed in this case, but there does need to be a good quality, perhaps combined, or a single litigant in this case taking on the responsibility to present the other side to the Court of Appeals. And Mr. Mills, you've assured me, and Ms. Williams seems to be bought into this, that a single brief could do that. But the real issue is going to be who's going to do that.
Your Honor, I would be more than willing to send my brief that's pretty much done to Joy and have her run through it and make any suggestion changes she wants, and we could work together in that regard. I think that would be a good thing. I like your idea, Your Honor.
All right. Now, I do want to hear from Mr. Weta here.
Thank you, Your Honor. Frankly, this is the first that I've heard that there would be a request to, other than the objection that led to here, that there would be a request that we all combine our efforts. Frankly, Your Honor, as you said, I believe that our work throughout the process of this case has been only that which is necessary. We made every attempt to avoid most of this litigation. And frankly, we did not file this litigation. Our position from the beginning has been that this was filed out of time, and all of the issues that are before the court should not have been before the court until a petition for final settlement was put forth, so that they could object and everything could be in front of the court as the court asked. However, these have continued to go forward, and they are issues that needed to be resolved. And frankly, from our perspective, we have done the barest minimum that we need to do to be professional in this case. I am not attempting to spend any additional time here as absolutely necessary, but there have been significant briefs that were filed in this case with case law research from multiple states that had to be addressed to ensure that the court was getting to where it was supposed to be. And so I understand the court's position, and frankly, I share the concern, as well as the fiduciary shares the concern that she has a fiduciary responsibility to all of the beneficiaries. And frankly, that's why we're stuck in the situation that we are today. We would have liked to have filed a petition for final settlement, but given the appeal that is going forward, we frankly don't know what the appellate court is going to rule. And if Mr. Cranmer is successful on his Strobel argument, it will greatly alter what the fiduciary believed was the proper distribution. And frankly, this court's orders up to this point have also altered that. We could submit a petition for final settlement, but frankly, I don't believe the court could rule on it given the pending appeal. And so to the extent, I guess to the extent that I'm being ordered not to participate in the appeal, I can do that, but I'm very concerned for both my own license as well as my client's fiduciary responsibilities to the estate, that I not be part of that and ensure that things are going forward. And I cannot be, I guess I'm not 100% clear what the other party's exact position is on Mr. Cranmer's argument, but I do believe that you're correct. Our position, frankly, would be as it has been throughout this entire argument. So, I guess long story short, I'm caught a little bit on the back foot, frankly. We've done a bit of preparation work for the appeal, but frankly filed a request for a second extension today to make our brief be due in mid-January, and expected to have that brief done by that point. I suppose we can back off of that, but again, my client, as the administrator CTA of this estate, is named as a party in that appeal, and we need to ensure that she does not face any sort of repercussions from anyone, regardless of the outcome of what that appeal is, if she chooses not to participate in that appeal.
I don't think I went any
Your
further
Honor,
than, okay, go ahead.
Oh, I apologize, Judge. I don't know that Mr. Wetta needs to completely not be a part of the appeal. I know Mr. Mills is advocating for that, but I don't know why the three of us can't weigh in and do one common brief and cut down on the attorney fees would be my suggestion. Not that we're cutting an attorney or a party out of the case at all. That was not what I meant to suggest to the court at all.
Mr. Mills, you've already done a rough draft of a response brief in the case?
Yes, I do, Your Honor.
Well, I would think sharing that with Ms. Williams and Mr. Wetta would be the next step.
Well, I'd be
What I've
happy
tried to
do-
make clear is this court is not going to favor Mr. Wetta filing a brief separate from the other persons who are united in interest, though I do understand his client's fiduciary duty in this case. But again, if she wants to subsidize, at least initially, a separate brief, that's her decision. But I think that then we're looking at this court considering compensating her for what she's out of pocket, rather than just simply saying Mr. Wetta can just continue to spend thousands of dollars of estate money to file a separate and independent brief. I just don't think it's necessary here. And I think the court needs to look at as what is just and reasonable and necessary are all statutory terms. So I think this was brought to a head by the motions in this case. But again, counsel, I am encouraging you to file a common brief and hopefully not delay it. It does appear that Mr. Wetta's firm was ready to go forward with it soon. Every extension requires additional time and additional delay. This case does need a conclusion someday. And I would
Your
like to
Honor.
live long enough to see it.
Me too, Your Honor. Your Honor, that I do know that counsel, Mr. Wetta, has requested another extension. I was hopeful that we could, not have to extend the time to file the brief. I could send it to everybody, immediately, if the court wants me to. But the other thing is obviously my brief isn't set up to include all the other parties besides Mr. Cranmer. He's the appellant or the appellee. So we would just have to tweak that a little bit. And then I guess if they want to critique my brief, they certainly can and make suggestions, and we can implement them as quickly as possible. I'm just Your Honor, you're just spot on. I mean, you really are, and I'm glad that you're doing what you're doing, because we do need to save as much assets for the estate as we can in this regard.
All right. Well, I hear some consensus here about some cooperative effort regarding a response brief involving all persons similarly situated. And it's the court's perception that you three, Ms. Williams, Mr. Weta, Mr. Mills, and your client's positions are all united in interest. Turning then to the adversary. Interestingly, also before the court today is a petition for allowance of interim attorney fees filed on behalf of Frank Bly and Esme Pearl, the biological children of the deceased Larry Franklin Holderman, the two kids who were, under the terms of the will, disinherited. Mr. Cranmer, I've read your petition. Is there anything further that you would state in regards to your petition?
No, Your Honor, I think basically my petition was pretty short and concise. I relied on the statute in two cases, which I put forth in there. I really would be, in large part, repeating what I wrote, maybe adding a few words or something, which nobody necessarily needs to hear, I guess. But no, the point is that we believe that the litigation was, advanced in good faith, that the time was all reasonably necessary, that my hourly rates of myself and my staff were all within the bounds of what opposing counsel have set forth in their previous requests for fees, and they're customary for this area. And I think that the litigation advanced the estate as an entity to make sure that we got the division right and applied the construction of the will to the law of the state. And that's what is the basis of my request for an interim allowance of fees.
Was it Mr. Mills that initiated the litigation to construe this will rather than you and Mr. Cranmer?
Mr. Mills was in the case before I was and had started it, but we entered and then we brought the Strobel argument, which had not been before the court to my knowledge before I got involved, on behalf of Frank Bly and Esme Pearl.
And of course, this court ultimately ruled the Strobel is not applicable. I noticed the cases that you cited, Mr. Cranmer, but this court is more inclined to rely on a more recent case than the cases that you cited. Mildrexter, 25 Canap 2nd 834, a 1999 case. The Court of Appeals in that case said the clear language of the statute indicates 3 threshold requirements must be met before attorney fees may be recovered. Number 1, the party must be successful in his or her action. Number 2, the action must ultimately benefit the recipients of the estate. And number 3, the court must exercise its discretion to allow fees. Well, let's analyze those. Number 1, your parties, the parties that you represent, must be successful in their action. They wholly were unsuccessful in this action. They brought litigation in which this court ruled against them across the board. They're still, under the rulings of the court, not a potential beneficiary of this estate. Again, the Court of Appeals will ultimately issue their decision, but at this juncture, the court cannot find that the parties have been successful in their action. It doesn't ultimately benefit what this court sees to be the ultimate recipients of this estate. In fact, it would completely take the estate away from these people if you were successful. And then number 3, the court must exercise its discretion to allow fees. Well, under these circumstances, with the request being for unsuccessful parties and the court's obvious concerns that have been expressed about how quickly this estate asset pool is being depleted by litigation and claims by attorneys, this court would certainly exercise its discretion at this point to disallow the petition for allowance of interim attorney fees, finding that what this court views as the current beneficiaries of this estate should not have to subsidize an appeal that's intended to go against them. And so the court's going to deny the request by Mr. Cranmer on behalf of his clients for allowance of interim attorney fees. With that said, Mr. Cranmer, you're a good lawyer who's diligently represented your clients, but that's not the test. The test is, as the court set forth in the three-part Mill-Drexler analysis, and following that analysis, which I believe is current law of the state of Kansas, your clients are not entitled to fees, at least certainly not at this juncture. So that request is outright denied.
Well,
All right.
I believe is a Court of Appeals case. The cases I'm relying upon are from the Supreme Court, and they say that you whether you're successful or unsuccessful. So I don't know that the Court of Appeals can overrule a Supreme Court case in that regard. That would be my response to that. I mean, that's not what the law is mandated by the Kansas Supreme Court.
But element number 3, even if the court were to construe that in your favor, is it not discretionary with the court as to what, if anything, is allowed? Rather than a mandatory obligation of this court, it would be discretionary, would it not?
I think I think it's the Robinson case says it's proper for the court to award fees but whether you're successful or unsuccessful.
So wouldn't that just encourage everyone to bring all kinds of spurious litigation in estate cases just so lawyers can get paid?
Well, if it's spurious and it's not benefiting the estate, I'm submitting that what I've done has benefited the estate because it brought the Strobel claim forward, which had not been before the case, and it benefits the estate and the administrator CTA to know that how the money's dispersed is dispersed in accordance with the law and the construction of the will.
As I understand it, had this court applied Strobel, it would have essentially just disallowed all of the provisions of the will which dispose of the estate. This court upheld that will.
Strobel, had a court applied Strobel, it would have meant that the will failed because it was incomplete, because it didn't have a residuary clause to complete the disinheritance, and therefore would have passed by intestate succession, not under the will.
I think the record is quite reflective of the court's ultimate ruling in that regard. The court did not accept that argument, obviously, and entered rulings which essentially upheld the will, finding that there were still beneficiaries from the will through line of succession that still existed, which distinguished it from Strobel. And the court's not inclined today to revisit that earlier ruling.
No, I wasn't asking, I wouldn't ask the court, I was just substantiating my position for my request for fees that were benefiting the estate. That's all I was doing. I'm not asking you to re-litigate that.
And the court finds no benefit to the estate. So
Okay.